Yes. Number 266.
Yes.
This is the order. The hearing is concluded. Only one. It is also within one judgment, my lord, sought from us. This is where my mother applied, and after 16 years, she forwarded my name. She could not get the appointment.
It's on the list.
Yes, 266. It is not being taken up. So
don't worry, it will be.
If
Now we are
fixes only one, it will take only 1 second.
for a week. How it progresses, you see, then you can.
Yes.
Your Lordship, may I be permitted to mention a matter? This is a City Court appeal which was released by His Lordship, the Honorable Justice Harish Tandon, while he had, as His Lordship then was, when he had the determination. 2 applications are pending and the appeal is ready for hearing. If Your Lordship pleases to hear this matter, then we are ready for it. Or if Your Lordship pleases, Your Lordship might release the matter and we might mention it.
It has been released to us. It has been assigned to us.
Lordship pleases to release the matter.
Take the slip, call for the file. Let us see. Let me see what it is.
Yes.
We'll see, then we'll take a decision.
My lord, my lord,
Might keep it as to be mentioned or okay.
So take the file. Give the file. We'll see the file, then you.
my lord, mention my prey.
Include it. It is for inclusion. Yes.
Item number 2.
I've done it for 3 weeks.
Mr. Taruk Paron is appealing for the state. Now he's on his way.
You can see. 17 must not be 17. The case is of 17/10/17, so this date must be different. Wrong date. Here it is the Rampur PS case number 22 dated 17/10/2017. None appears.
Item number 3.
I beg to appear on behalf of the appellants in this matter, Lordship, Union of India in this matter. Lordship, was last heard on one by the coordinate bench, Lordship. I am beseeching you, Lordship, I have some time, but otherwise, he is ready for hearing, sir. In fact, coordinate bench, it was substantially heard. The moot point which was raised before the coordinate bench was the whether the petitioner would be entitled for the full pay and allowance for the period of his suspension, Lordship.
Suspension.
Suspension period, Lordship. And also the second point which was raised appeal was the superintendent and the control of the Director General of the Border Security. For that low point, my esteemed senior friend, Mr. Mr. Shomo Majumdar, one senior advocate, he referred to one judgment of the Honorable Apex Court, wherein Bombay Civil Services rule was referred. Order dated 15th of February 2021. Coordinate bench then directed production of that Bombay Civil Services rule.
15th March.
15th of February 2021. I believe still yet to be received by the registrar of the Supreme Court, Lordship.
Why?
Was whether during the period of suspension of 6 years, no departmental inquiry was proceeded against. All of a sudden, it was revoked. During this period, Your Lordship, that is what we have prayed for.
Oh, the Union of India is in appeal.
Yes, Your Lordship.
Lordship.
What has the tribunal done?
Lordship, the
The Honorable Single Judge has done. Yes. Honorable Single Judge, yes.
Honorable Single Judge has directed for the for payment of first salary less the amount paid.
As subsistence allowance. So what is the period of suspension?
Not, I'll be very candid, Lordship. I'm not with the today, Lordship.
I was suspended on 9th of September 2013 and it was revoked, Your Lordship, by an order today, 10th of October 2017.
17. More than 4 years.
and no proceeding.
Lordship, department required the district authority, since there was a criminal case pending against the petitioner. That's why
On account of pendency of a criminal case, he was suspended. So the criminal case was lost prior to his suspension.
Lordship,
So what does the rule says? That is all that has to be seen in such a circumstance.
here,
Why a Bombay Civil Service rule is required?
Lordship, in fact, if your Lordship kindly takes up the order dated
He is a member of which force?
Border security.
border security force,
They have their own act and rules. So it will be governed by that.
governed by that. Certainly, it was the moot point before the coordinate bench. In fact, that the superintendents of the Director General for passing of any order or revocation of the order will be governed by the BSF Act and rules, Lordship.
Yes.
However, the moot point which was raised by my senior friend, relying on an authority of Balwant Ratilal Patel, but state of Maharashtra, Lordship, there the issue of Bombay Civil Services only was it was adverted, and that was the reason.
So they were trying to draw a parallel with that case. So to see whether the provisions are pari materia or not. May not be required. Let us just see the provisions of the act. We need.
In the meanwhile, Lordship, when the coordinate bench was in season of the matter, it was, however, it was find out that in the interregnum, Bombay Civil Services has already been repealed.
Whatever may be, he is to be governed by the rules governing his
Governing
service.
his service.
And whether if the rule has any provision of suspension on account of pendency of a criminal case, then it must be having the consequences of such if it is revoked. There must be a provision.
One thing which I would like to bring to your Lordship's notice is that also the fundamental rules here. Apart from the BSF Act, he is also governed under the fundamental rules, specifically FR 53, Lordship.
What does that say?
Fundamental 53 is the respect of the subsistence allowance. Maximum ceiling, as you are well aware, that it should be not more than 90% of the subsistence allowance of the payment of the full wage salary.
See, actually, the issue, whether it is a suspension or a dismissal based on conviction, these are the two circumstances. So here there is no conviction.
This matter was
No, the suspension was only on lodging of the case.
causing of the while this scheme was being heard, the criminal case was still pending, Lordship. The criminal proceeding was still pending at that relevant point of time.
Then why you reinstated it?
Lordship, that was
Why did you revoke the suspension?
done by an order, Lordship.
When do you want to argue? Tell us.
I was beseeching your Lordship, kindly grant us at least 3 weeks, Lordship. In the meanwhile, we'll get ready with the appeal, Lordship.
He is still in service.
No, Your Lordship, we have that.
We have that in 2019, Lordship.
19 during pendency.
2019, Lordship.
So depending on the order passed, his retirement benefits will
Affected, Lordship.
may be affected. Whole matter, get ready. It is submitted by Mr. So
It has to. This has been considered.
Item number 4.
With 20 requisition without certified. The appeal is
Item number 5.
plus Must be during COVID times. 110/20. It have been filed during COVID times. Same on. Should also be taking out the episode. Takes
Item number 6.
is going to appear to be. There are more defects. Holograms. The present appeal is filed with
Seven.
Item number 7, Lordship, I'm only paying for not today, Lordship. This matter was filed on in the year of 2020, Lordship. It comes yesterday, Lordship, come to the list, Lordship. I am unable to bring the brief, Lordship.
You are unable to?
Bring the brief, Lordship. So I will come by tomorrow, Lordship. Only paying for not today only, Lordship. It's an old matter, Lordship.
You have not removed the defects.
Then, Lordship, I will remove the defect, Lordship, accordingly, Lordship. Then the direction may be passed to removal of the defect, Lordship.
And an advocate, you are Mr.
It should not appear to counsel as well.
8.
None appears on behalf of the writ petitioner.
nine,
Who has said that the court should not proceed without express.
Yes,
Referring to the respondent, your lordship.
yes.
The applicants are not, your lordship, the applicants are not
You are for the respondent.
the respondent, your lordship.
Union of India is in appeal.
Yes, your lordship.
What is the order?
Lordship, it's an order of 17th June. The, it's on page 164.
64.
164, your lordship. Volume 2. By the order, summons issued against against the respondent was quashed because it was not meeting the requirements of section 108. And the customs were directed that they are free to inquire within the own customs territory. The operative portion, your lordship, is on is at part. I'll just lordship, it's on page 170, 200.
None appears on behalf of the appellant. Why two cases have been filed?
Lordship.
Why? Oh, because there were two persons apprehended.
Yes, Your Lordship. Two persons, two separate summons were issued. Both were challenged.
Came on.
Give
your appearance.
Lordship, one request to Lordship. There are multiple seniors also in the matter.
Huh?
Lordship, there are multiple seniors in the matter. Would Your Lordship be pleased to keep it post the puja vacations, if Your Lordship feels?
None appears on behalf of the appellants in both the matters. There is some can pending.
Lordship, they had filed a can. Lordship, it's showing as pending, but I don't. Lordship, I'm not sure. I'll have to check. I think this.
What is the number? What is the number?
Lordship, can one.
One on the list. So can one, perhaps it has been disposed of. At least in MAT 743 it has been disposed of.
Your Lordship, it must be the same for both the matters.
Must be the same. In the second case, let us see. This is the second or first case? That is already disposed of. Can one is already disposed of. In 9 also there is a can. Let us see.
Lordship, the can has been disposed of. There was an order passed on
In both the
10
cases.
10 December. It was said that there is no scope of an interim
In
order.
item 10 we have seen that order, but about 9 we are looking at 9 now.
Lordship, 9 as well, Your Lordship. 10 December 2020.
And it's in this case it is pending.
No, Your Lordship, I can see an order in item number 9 where the no interim order was passed and can has been disposed of. 9 to 7 for Lordship, in both the matters, the same order has been passed.
None appears on behalf of the Here for the respondent. Don't say anything when it comes on the next day, please. Let it go as it is. Nothing has to be.
Item number 11.
11, my lord, I am appearing for the appearance, my lord. The substitution application, my lord. Arising out of contempt.
Delay condone. There is an application for substitution,
And
another application for condonation of delay. 734 days delay. And this Honorable High Court, because of the repetition on 5th July 2018, matter was remanded back to the tribunal. What happened to the
Yes, the appeal is against an order of remand.
No.
my lord,
If
there are
refusing
specific
to
order
interim
by
order,
the honorable court, my lord.
refusal to pass the interim order, approach this Honorable Court. This Honorable Court directed to make payment without prejudice, pending decision of the tribunal. Now, moreover, I find that they filed an application for contempt, and in the meantime, the original petitioner died in 2016, 13th February 2016. There is a delay of 734 days. And none of the contemnants are in the office because of 2006 matters. Section 5 application. An application for substitution. Can number 2 and can number 3 is condonation of delay.
I may be permitted to incorporate the name of the new incumbent. I may kindly be permitted to incorporate the name of the new incumbent.
Union.
New incumbent as container.
Substitution, there is a substitution pending.
Application for substitution, application for condonation of delay, and for contempt.
Contempt.
Container.
Which is the substitution application?
Can number 2 of 2022.
So, under substitution.
That will be money though. Yeah, Bhaskar Watch is so regular.
I'm filing the substitution. That's good. It has been served on you.
Alright.
These can applications have been served on you.
But not the WPST. The main read petition, that has not been supplied. Application for substitution and but the contempt application is not. Yes, contempt application is there.
I have served my contempt and substitution. Delay, condonation of delay I have served. The original petition, your lordships are pleased to us to call it by my learned friend.
Yes, we have seen that order. We have requested him.
Fine.
So therefore, we are asking him, since he has appeared late,
Fine.
does he wish to file any opposition to the applications, or you want?
What contempt? Yes, one of that.
No, there are three applications.
There are one application for contempt, one application for
Substitution and one for condonation.
certificate amendment and condonation of delay.
So which application you want to file in opposition?
The contempt application. Provided this application is allowed. Condonation of delay and
What is the period of delay?
734 days. ট্রাইব্যুনাল কি হলো? ট্রাইব্যুনাল কি হলো? ট্রাইব্যুনাল তো পেন্ডিং ছিল। হ্যাঁ হ্যাঁ তারপরে
You file an opposition to all the applications.
the only difficult is matter until the cost title is changed, it will be very difficult until the name of the present incumbent. Well, all of them are retired.
All of them are retired.
Retired. And whether they are, I think, and some of is no more in the world.
So you take instructions whose name is to appear in their place, the contemners.
Kullan Bakshi, if I remember, he retired in 2011, and Dr. Bakshi also retired. Shantanu Haldar, he also retired. Nirmal Chand Devnath, he has also retired.
So we'll adjourn it for filing opposition to the applications. In the meantime, you get this information also as to the name of the contemners. Both things you can do. We can list it after 3 weeks.
Present incumbent Dr. Soren name, I can immediately supply Director of Health Service.
Huh?
Present incumbent Dr. Director of Health Service.
How many contemners?
4 contemners.
You know the name of all 4.
Only one I the director.
So therefore, we are saying you find out name of all 4 persons, and in the meantime, you file in opposition also. There are the learned AGP submit 12. None appears. You are not appearing. None appears for either. Thirteen.
Thirteen.
23. None appear for the parties.
Am appearing for the petitioner. I will kindly take up Lordship's last order, my lord. 6th December, my lord. Last order.
দিতে অর্ডারটাতে অর্ডার ডাউন হচ্ছে জিনিসটা কেন করবেন এটার জন্য
I have got a very dim but very bright ray of hope. I'll kindly see. দাঁড়ান বলছি স্যার, একটু বলছি। I'll kindly see paragraph 3. (1994) 6th SCC 109.
কোনটার উপরে
এটা হচ্ছে স্টেট অফ মহারাষ্ট্র ভার্সেস প্রপোজিশনটা হচ্ছে প্যারাগ্রাফ 3.
তারা না হ্যাপি
3, paragraph 3. It is well established that factual of
হয়নি 2012 সাল থেকে
last 2 lines, my lord. Here, and subsidiary how to rebut his has also been taken off. In this case, my lord, even affidavit in opposition has not been filed.
কপি করে দিয়েছে ভিডিওটা দেখেছেন আছে
The factual recitals or observations made in a judgment or order,
Yes, that is a judgment.
not a set aside judgment or order.
Well, it includes a set aside judgment.
No, no,
Why?
no.
My lord? It has, my lord, I'll help to expand on so many things if I go that way. First is, my lord, a decree, any observation, finding of fact in a decree shall remain binding, my lord, has an evidentiary value under section 114 of the Evidence Act, my lord. Because, my lord, in any decree, my lord, or judgment, my lord, if a fact has been recorded, it remains there unless that fact itself is not set aside. Even in if you apply the doctrine of merger, my lord, only those portions which have been set aside are merged, my lord, in the merged judgment, my lord. A part of the judgment which is not set aside does not, it is
You're relying on which judgment?
still remains
You're relying
No.
upon the observations or recitals in which judgment?
of the High Court, my lord.
Of the High Court.
My lord, the order was set aside not on facts, my lord. The order was set aside only because the court was of the opinion that in contempt proceedings you cannot pass this order, and liberty was granted to you go and file separate. Admittedly, there was contempt was committed. That it was held that contempt has been committed. It was held. The court, honorable court said that no contempt has been committed. And in fact, it is one of the leading judgments in respect of that during contempt proceedings. That is this is a reported judgment, my lord. So, my lord, in this case, it is different, my lord. They themselves came up before the court several times and filed affidavits, my lord. In that, there was one of the observation. It was not even admitted by me that this is the case. My claim was much higher. My claim was on the basis of another employee who was getting higher than me. So, my lord, that lapsed with the order passed by the Honorable High Court in a separate proceeding. After that, my claim was that if I am unable to get that, you give me whatever you have admitted before the court of law. That was my simple.
The order of the tribunal impugning the proceedings
Said it is barred by res judicata.
No, in the present proceedings, which order is pending consideration?
In the present.
This is a writ proceeding
Yes, yes.
arising out of a tribunal's order.
Yes, yes.
Which order of the tribunal?
Here also there is a bit confusion.
That's why I don't remember very clearly, but I do remember that there was some.
First
Order
order was
200.
Huh?
Order passed by the learned tribunal in a miscellaneous application.
first.
Passed by the tribunal?
Yes, MA.
ওটা subsequent হচ্ছে
Then
subsequent হচ্ছে আমি explain করে দিচ্ছি my lord. First, my lord, an order was passed. In that order there was an observation that you have misled the court, specific observation
Against you.
against me. So after that I challenged it before the Honorable High Court. The Honorable High Court said as long as this observation remains, we will not proceed. So I went back, my lord, against miscellaneous application was filed. Then, my lord, the Honorable Tribunal corrected their observation that no, the whatever observation is limited to this proceedings. Then I again subsequently filed an application.
So where are these two orders? Let us.
Page once the first order, the main order, that is at 178 to 186.
$960. OA 960.
Start from page 181.
960.
Yes.
thank you. সেই গুরুদাস কোথায়? মনীষ গুপ্ত সে গুরুদাসরা ঘরে রয়েছে, সেই গুরুদাসরা কে বেঁচে আছে এখন? হ্যাঁ?
আপনি
খুব
জানতেন?
আচ্ছা, বেটে করে ভদ্রলোক চেম্বারে দেখেছি, বেটে করে, তাই না? টেডি,
ছিল
হ্যাঁ হ্যাঁ হ্যাঁ, গুরুদাস রায় কন্টেম্প হয়েছিল,
ওইটাই।
এখন মনীষ গুপ্ত হোম সেক্রেটারি ছিল।
এই এখনই যেটা এখন এসসিসি থেকে
খুব সুবিধা হয়, বই পারো না আমার, অনেক উঠতে হয়। না আছে আমার 50 সাল থেকে, না আমার 1858 থেকে আছে বেঙ্গল ল জানো, তোকে বই কি সুযোগ করে। ঠিক আছে, খুলে নিয়েছো এআইআর 1995
নিয়ে
আছে।
The claim has been held to be barred by res judicata.
Although your lordship has seen this paragraph, although in the last line the dispute between parties relating to seniority
হ্যাঁ,
of the applicant and the matter relating to subsequent fixation pay have thus reached finality. This was a totally different matter, my lord.
Where are you reading?
My lord, last line of paragraph 1 is page 185, last line, my lord, the same paragraph, your lordship.
Give us the internal page of the judgment.
Internal page 6.
The matter relating to fixation.
Yes, ma'am. The disputes between the last line.
No, but you filed an OA 954 of 96.
Previous. Yes. Before that. When that was dismissed, I came up before the Honorable High Court. That was also dismissed against me.
954 of 96 already dismissed on the same, it was on the same issue.
On the issue of, no, it was on the issue of seniority. The tribunal is also recording the same thing. Last line, Your Lordship, kindly, page number 6, last line. The dispute between the parties related to seniority of the applicant and the matters relating to subsequent pay fixation have thus reached finality. I was not claiming this in before the tribunal because that had in my, it was my admitted case that that issue has reached finality. I was not entitled to higher pay. This issue had reached finality. It's
No,
correct.
the pay fixation was left to be agitated by an order of the Supreme Court passed in civil appeal number 1467 of 95.
Right.
Thereafter, you moved the tribunal in 954
Yes.
for that relief.
I raised the same issue. Same issue.
Yes, that is the liberty was granted. Where is the order of the civil appeal? Pursuant to that liberty, you moved the OA 954. So where is the order of the apex court and the prayer in OA 954?
It is, the order is at 82, my lord, page 82. You'll have to kindly see, it starts from page 82.
84.
82. Page 82. It's a reported judgment. So,
What page 82? Justice Agoral judgment.
P5.
P5, yes, sir. The last paragraph at page 86, liberty is granted. Well, kindly see which 20, paragraph 20, just the page before that. Paragraph
Page 85.
Paragraph 20, page 85, Mother. We do not propose to go into the question of interpretation of Rule 55.4. My claim was based on this, Mother. That when a senior person junior to me gets a higher scale, I am also entitled to that.
So therefore, ultimately, it was all hinging upon whether you will get 2070 or not. If you get 2070, then the cascading effect will be that ultimately you will reach the higher pay.
Possibly that was not the issue. That
Let us see.
Their admitted cases. They were always.
That is what you are claiming. Even in the tribunal, you are claiming the same thing. Even before the tribunal, you are claiming the same thing.
No, I am saying that they have admitted that amount during the process.
Correct. And you say the moment it is granted, I will become equal to others that Mr. Roy or whoever you are claiming parity with.
Possibly not.
On Rishikesh Rai.
Yes, Mr. Rishikesh.
Rai. No, I will remain junior to Rishikesh Rai. Because that is the pay scale fixed by them. And the court was not satisfied even with that. My salary 2070 as on 1/5/1991, they had fixed, Ballot.
At what?
During the proceeding, Ballot, I had final calculation had been placed, Ballot. I had on the last occasion read out the whole judgment, Ballot.
1591.
Yes, Ballot.
So we should remember it.
No, I will repeat it again, Ballot. It will take a long time, Ballot.
No, we are just trying to understand because you are saying.
Well, I am trying to say this.
Yes.
During a proceeding, kindly forget. During a proceeding, this contempt proceeding, the court repeatedly gave them chance to fix the pay, and one after another they started paying, giving different calculations. This was the last calculation submitted. Where as on
1591.
it was fixed. They said.
No, they say that we have never given, that was given by the advocate.
From the judgment, it appears they had submitted.
No, they say it was given by the advocate, it was not given by.
That was my case, my lord.
Oh, yes, so
My
that is.
case was, an allegation was made that I have fraudulently put a chart.
Yes,
The reliance was on the actual observation of the judgment. Reliance was, in fact, the chart was in
calculation sheet.
Calculation sheet.
Yes.
What had happened? It was in fact 2 pages of 2 different values, which I, as an advocate, I ignored at the time of filing. It is a fact.
You gave that calculation.
Yes.
The applicant.
Applicant, no. These were times handed over by the advocate to the who were appearing in the contempt proceeding to the petitioner's advocate. So somewhere these 2 pages got missed. The chart was in fact correct. Incorrect. In fact, incorrect. But the fact is apparent from the observation of the order.
So what was your prayer in 954? Let us see. Of 96.
Of 96.
954.
Okay.
Because the tribunal has held that it is barred by res judicata on view of the order passed in 954. So we want to see what was your prayer and what was your.
That previous application possibly was not filed.
But that is simply.
The judgment was filed. The judgment was filed.
But then how do we understand whether it res judicata will apply or not? If there was a prayer, if it was considered, if it was not considered, this is the fact. The dismissal of the OA is on this ground. You see page 6.
Yes.
Page 6, last paragraph of the impugned order. It says that this OA was dismissed on contest, holding that there is no merit. Therefore, this issue having concluded between the parties, there is no scope for looking into again. Therefore, we have to see whether it if this finding is correct, then we don't know. If it is incorrect, then everything is open.
Leave to bring that application, but the conditions are such.
But we have to understand this. We have
But
to.
I was drawing from the tribunal's own wordings, my lord. There.
But the tribunal's conclusion is that you will be bound by OA 954 of 96. It says nothing beyond that. You can't do anything now because 954 96 covers your rights arising in the present OA. You see the last paragraph at page 6. Please just go through it.
Start from the last paragraph, starts from the very word, the matter related to fixation of seniority.
Yes, please read complete. Yes.
Subject matter of series
of. So this was the subject of series of litigation, finally settled by the apex court.
In case of Manish Gupta, allowing the appeal, setting about. In fact, this again, order. It did not settle that issue. It settled that.
Now, the applicant was, however, allowed liberty to pursue the remedy which may be available to him in law in relation to fixation of his pay on the post of UDA. Thereafter, he filed an application 954 for relief under rule so-and-so, which was dismissed on contest, holding that there was no merit. Subsequently, he moved the Honorable Court in WPST, which was dismissed. The dispute between the parties relating to seniority of the applicant and matters relating to subsequent pay fixation have thus reached finality in judicial proceedings.
Well, that is what I am saying. From this line also it is apparent. Before the tribunal for relief under section 55(4) or WPSR.
Yeah.
And also subsequent pay. After my seniority, subsequent pay.
No, but if everything is concluded, the tribunal says, what is that?
May I make a difference here? What tribunal is, if the tribunal says that it is barred by res judicata, it will be completely wrong. what the tribunal
So
would have
that is what we are trying to see, whether this conclusion is right or wrong. How can we see unless we see
I
what you
understand.
had approached the tribunal?
I would have brought the prayer, but the petitioner is very ill, my lord. My lord, I don't know how I will be able to get that away.
But can we ascertain in the absence of
Well, kindly
whether it was an issue, whether the issue was decided, whether it was between the same parties?
I am thinking very hard on the wordings in this paragraph, my lord, at page 6. Thereafter, the applicant filed an application of 954 before the tribunal for relief under section 54(4) of WBSR.
Yes.
That is why I am saying, my lord, and that which was dismissed on contest, holding the subsequently applicant moved for the same matter
Yes.
in WPS,
Yes.
meaning by rule 55(4),
Yes.
which was dismissed by judgment after the dispute between the parties relating to seniority.
So you want us to accept the tribunal's recording to it to the extent that it is helping you. The other aspect you don't want us to read. How can we do that? We have to ascertain based on the records whether this finding is correct.
Correct, my lord. No, I am.
Otherwise, how can we get to the bottom of?
My lord, I am.
No,
I
then
will try.
you please tell us then how it can be resolved.
I will try. Why your lordship can send it back to them, or they can either bring their record whether this is correct or not. Only in this thing,
See, if
because
it
they
is-
have not even filed an opposition, my lord. In spite of repeated opportunity, they have not filed a. So they have not even denied my allegations.
No, but the tribunal's finding is
I understand if that would result, you can show the prayer. If I can show the prayer of my.
if this was not an issue, then it is totally everything will be open.
What I was ready for arguing at that possibly the tribunal wanted to say that this is barred by order to rule 2.
No, it says so in so many
But
words.
it says, but words are not matching what it is saying that, my lord.
The principles barred by principles of res
Res
judicata
judicata,
and fails on that ground. So it is.
but it is not.
So where is the order of 954 of 96?
What is it?
And 54.
Just locate it.
Page 1. It is at page 149. Yes, my lord. Yes, my lord. Here it has been held, my lord. Same middle paragraph, my lord. Looking into various orders passed from time to time from the judgment of the Honorable Supreme Court dated 9th February, etc., arising out of SLPC, it appears that the question which has been raised by the petitioner before the learned tribunal was also considered by the Honorable Supreme Court, and having regard to the observations made regarding the applicability of Rule 55(4) of the West Bengal Service Rules, Part 1, we are of the view that the order of the learned tribunal impugned to the writ petitioner does not merit any interference. You kindly see subsequent. It may, however, noted that during the course of Mr. Paja, learned advocate appearing for the respondent, produced a copy of the memo dated 8th August 2020, for which appears that petition has been promoted to the post of section officer, but fixation of his pay could not be done, owing to his non-submission of option. However, on behalf of the petitioner, it has been urged that the petitioner has submitted his option and that statement made in memo is not correct. Be that as it may, the respondent concerns are directed to refix the pay of the petitioner upon promotion to the post of section officer, keeping with the options already submitted by me, since the petitioner is due to retire shortly, in fact, few days, the end of that month. So after that, they refix my pensions. Then I file the next OA before the tribunal. In fact, if your lordship sees my application,
0 is after this.
After this.
And my lord, if your lordship sees, my lord, page 103, this is page internal page 8 of my application, 960.
So 105 is a prayer.
No, prayer.
And prayer. Paid 105.
Pleading double.
100 and
Kindly see my
page
page 103, internal page 8, my lord.
of the tribunal's order.
No, no.
My
this is OA.
my application. It was my application, my lord, before the tribunal, on which the order has been passed.
Page 103.
Yes, ma'am.
So the OA is part of the record.
Yes, ma'am. No, this is the my subsequent previous OA is not there.
So 954 is not there.
Here, my lord, I have specifically stated that facts. That it has been subsequently refixed. Now these facts have not been taken into account. I have listed out the fact, 6.18 paragraph, my lord. So I am no longer claiming that benefit of seniority.
Before we proceed, can you just give us a list
Of dates, my lord.
Yes.
the judgment order wise
Yes, yes.
in seriatim,
Yes.
so that we can go through it and then we'll
Correct.
otherwise
But so many orders are passed by the High Court.
no,
different
but
ways.
now it appears that we'll see.
Yes.
Just give us the seriatim wise,
Yes.
we can keep it in the next week. The learned advocate for the applicant.
List of dates. And 25th August.
20th, 20. All right. 20th is all right.
The last one. Can has been. And for restoration. Where is can 2? 2020? Huh? 785. Not there. Has to be tagged. But there are 2, 3 cans listed. There is a can 1 of
My lord, I'm praying for 2 weeks adjournment on behalf of Indrani Chakraborty. I'm praying for the union.
Huh?
I'm praying for 2 weeks adjournment on behalf of Indrani Chakraborty.
You are for the respondent.
None appears for the writ petition. None appears for either parties.
My lord, I am for the respondent. May I pay for not today?
Lord, if your lordship then kindly fix it next Thursday. I have some difficulty also.
It will come on Thursday itself.
Then, my lord.
Not today. It will come on Thursday.
Deep reference.
Item 19, I appear on behalf of the appellant. My lord, the advocate on record today in the morning, he gave me a telephone that he has some personal difficulties in his house for which he cannot come. I think
Not today. It will come on Thursday. We are taking up the hearing matters on Thursday.
my long back action for production of record by this honorable court. Affidavit has already been exchanged. Subject matter.
Impugned order is 22/11/2011.
We have challenged the order of dated 22/11/2011. It's not the fact is that the rail has advertised for recruitment of gangmen. That has been procedure of recruitment was initially first that paid physical endurance test to be conducted. If the candidate succeed in the physical endurance test, then they will call for the written test. Accordingly, my lord, physical endurance test was held, and the petitioner's name, and that 2 days it was, my lord, held, and the name of the petitioner was, my lord, in the list of successful candidates. Subsequently, my lord, the Railway Recruitment Board cancelled the entire recruitment process for corruption. Accordingly, my lord, none of the candidates who have appeared in that test was called for any written test, and that it has been, my lord, cancelled. Subsequently, petitioner came to know some of the candidates who approached before the tribunal, my lord, they have been asked for written test. Accordingly, the petitioner filed the application before the tribunal for getting same benefit. In the meantime, my lord, tribunal passed an earlier order where 26 batch of application has been disposed of, where they have been allowed to written test. In my case, my lord, it has been taken the point that I have not been successful, therefore I have not been called for written test. That we have challenged it, and that it has been, no documents was placed, no list was placed, and according it has been, my lord,
my application was rejected. Then I moved this application before the under the petition, and in the prima facie, the learned court was satisfied and passed an order on 15 June 2015, directing the railway advocate appearing on behalf of the railway that enter list of the that paid case.
15 June
2015. Justice Matre as it then was and Justice Asa Aurundo.
in these proceedings.
Yes, in these proceedings.
June 2015.
Yes. State ballot. But once it has been ballot, the record was changed, but thereafter ballot it has been adjourned on that day, and thereafter ballot it has not been taken. Therefore, that document is very much relevant.
I'm saying on this due. Can you read the order? 15 June 2015.
Produce the record of which they are paid on May 20.
So 15 June 2015 order. Okay. Showing this order 15 June 2015 order showing. Have a look.
There is a direction. What is the note mean? That was the order there.
My lord, in this matter, I have been engaged by railway authorities to appear in this matter, but I don't have all the documents with me, my lord.
So there is no such direction for producing any records.
Yes, my lord. 24th February 2015, I have made a mistake. Since the learned advocate representing the respondent railway authority is not able to clarify the action of the authorities properly in the matter of recruitment of gangman in Kharagpur division, before this court, hearing of these matters stand adjourned till 3rd March 2015, when the senior divisional personnel officer AC Railway Kharagpur respondent number 3 is directed to appear before this court with relevant records. That is why I'm
different date.
Yes, that is, I mixed the date 24th February 2015.
Thereafter, they have been allowed to file a supplementary affidavit. They have done it. So now that record issue is over. They have filed a supplementary affidavit.
My lord, I don't have all the papers with me, my lord. I am requesting my learned friend to supply me all the papers, my lord.
We don't know if you will supply or you will have to get it copied. That you decide between yourselves. As jointly prayed, the matter is at
It will appear on
after the holiday.
Would it be possible for you to fix the matter any other before that thing? Of employment.
You are
I'm hearing with him.
on behalf of respondents.
Petitioner, he is leading me.
I'm letting him.
So both of you will make different submissions.
No.
He asking for
I'm
shifting.
after slightly. Not possible.
Not possible. Is it?
Item 21. My lord, Mr. Torunjoti Tiwari will appear behalf of the Union of India, but it is a change brief. That's for a reason I am praying for 2 weeks accommodation.
There is a sole petitioner. Yes. Any can is on list? No, there is no can. Not appearing. Is the relief. None appears on behalf of the writ petitioner.
Twenty-two.
22, I am seeking leave of this honorable court to permit me to appear on behalf of respondent number 9, 15, 17, and 18 to virtual mode.
Yes.
My lord, in this matter, Mr. Dolopati is appearing. These are change brief. Kindly make it not this week.
My lord, may I just indicate one thing with regard to my submission, my lord? My lord, the respondent whom I am representing are already selected candidates. The appellant is seeking appointment in one post. My lord, there was an order on 24 June 2013, wherein the Honorable Court was pleased to pass an interim order stating therein that let there be an interim order only to the effect that filling up of the vacant post of scientist grade C will abide by the result of this written. My lord, vacant post. We have been already appointed at the time of institution of the matter, my lord. So, my lord, my lord, submission will be, my lord, our presence perhaps is not required regarding into the adjudication of the dispute.
If you don't want to appear, you can.
No, my lord, no. I was seeking whether I can, whether
So that is something which will now be decided at the ultimate.
My lord.
What can be done today?
My lord.
Don't want to appear.
No, we will appear. I was seeking if our name can be explained. We will appear.
Not today, it will come on Thursday.
Okay, grateful, my lord. Grateful, man.
Thank you. The first one, I could say that in their mind, vacant post must have been filled.
23.
Thing of the vacant post is subject to please.
Kindly make it not today.
Last day also on your pair it was adjourned. What is the issue? Compassionate. Requires consideration. Same issue, whether it needs to be made out of 2003. Requires consideration. In 3 he died. She asked for a form. In 4 she made an application in favor of the son. And in 6 the format was submitted. You say that it is a belated application. She has already asked you for a form in 2000. But this is not a ground. Where is the rejection? This is the rejection. 4/6/2009. No, this is of 12/6/2009. This is not 4/6/2009. The impugned order before the tribunal is 4/6/2009. They have approached the tribunal for quashing of an order dated 4/6/2009 by the Director of Health Services. Oh. So that date has been mentioned. Actually, it should be 12/6 because the memo is of 12/6. 12/6. Wrong. Anyway, so this ground is sustainable according to which provision? You have filed a reply. No, we are asking you to show us where is the parameter set because it relies upon absence of a financial crisis. So where is this yardstick laid down that if a person has served for 29 years, he is above 51 and this is the emolument given to him, then he will be considered as one who is EMP. 30 MP we have.
But Mr. Kramulbari is appearing in this matter. Malat, today he missed the brief. Malat, only one day. Tomorrow he will do it.
Last day also, every day it cannot be adjourned.
Malat, only one day accommodation. Malat, he only missed the brief. Malat, he is ready to do this matter. Malat.
No, on the last day also you have prayed for an adjournment. This cannot be allowed repeatedly.
Brief
Why
is
you
not
have
doing it.
missed the brief? The
The brief
matter
is
was
not doing it.
posted on the list. You should have had the brief. This is 30. There is no finding regarding his monthly income. So 9,100. 9,000. No, but this 9,100, is it approximately 90%? That you have not stated. You have given a figure, but you have not said that it is 90% of the gross monthly income of the family or not. So what was the gross monthly income at that time? Or whether this is a salary specified for a Group D employee. There are two conditions in B small a and B small b. Either a monthly income is below 90% now in view of the amended provision, 80%, or the amount being paid is the salary for a Group D employee. Either of the two conditions. No, SAT has proceeded on a totally different, it has gone on the ground that it is a belated application. Yes. Yes, we have seen that. You have given the figure, but whether it is 90% or whether it is a salary being paid to Group D, we don't know. So if it is only it is conforming to this requirement, then only it can be accepted as a valid order. Otherwise, cannot. So how will you inform us? Page 20. So the gross monthly salary is 13,220. So 90% of 13,220 will be more than 9,100. No, but this falls short of 90%. 90% of 13,000 will be somewhere above 11,000. It cannot be 9,100. Let her come back with this instruction. Current 24. Yes. You are appearing. Huh? 25.
24.
Today we are giving. Today again there is.
This is my application for restoration, my lord. Restoration, my lord. And that is a delay. I have applied for condition of delay. The kindly restore the application, considering the delay, my lord. Let me original matter be hard, my lord.
Restoration is can number?
Can number 2, my lord.
Can 2. And what is can 3?
Delay. Condition of delay. There is a delay of one and one.
Not in file. Both can.
One.
Both can is not in file. Yes, Limitation Act applies. Queried proceeding. No application of Limitation Act. Why a condonation is required? But the can is not on record. We don't find the can. When can 2 perhaps is the restoration.
Yeah, before your question.
Huh? We find that can 2. Take down. Cannot be on 18th. Then it will come on 21st.
21st, no problem. 21st.
Yes.
That's just to do that.
Yes. 26. Two days. None appears. On behalf of the
State matter item number 1 and 2, Sajol Datto.
My lord, I appear for the appellant.
Lot of equipment price has been made over the equipment being second hand.
Lot of hue and cry has been made by the appellants in these proceedings or before in the writ petitioners, the equipments being second hand. Lordship, this was perhaps the point raised before the CLB in the first round of litigation. May I just show what has been the finding of the CLB in the first round of litigation, which culminated into the Supreme Court decision. My lord, the paper book volume 5, if your lordship takes. The lordship, page 435.
Starts with 575.
75. আমার ব্রিফে তো এটা ভলিউম 5 আছে। But well, I'll skip this portion. I'll come back to this later, my lord. My lord will then consider this aspect, my lord. What Mr. Mitro has already placed just for the purpose of, my lord, what was before the RBI to be decided. What was before the RBI to be decided was whether a permission can be granted or not. It was. My lord, what was perhaps to be decided by the RBI was only in respect of section 19 of the FERA and 29 of the FERA. Nothing else was open to the RBI to be decided. But my lord, in that proceedings before the RBI, my lord, there is no whisper or there has been no statement made. The appellant before your lordship appeared on behalf of the company, and no question or no statement has been made with regard to his individual right as a shareholder. And he has not espoused one line in or one statement in that order in his submission with regard to the fact that his right as a shareholder would be jeopardized. His shareholding would be reduced. On the contrary, he has already taken steps to protect his shareholding, to protect the shareholding of the appellant before the company law board, which culminated into a judgment, thereafter challenging it before the Honorable High Court under section 10F of the company law, which is still pending, but that matter has been recently been mentioned. So your lordship will kindly consider a situation which has arisen is that one hand in the company petition, he espouses his right as a shareholder. And also in the writ petition, he tries to espouse causes as a shareholder when nothing is on record today, how his shareholding. Mr. Mitra has elaborately placed the writ petition. There is not one pleading with respect to the said fact.
He has said that there is no allegation that there is no allegation in the writ petition that RBI permission was causing any prejudice.
Any prejudice? Vis-a-vis, well, lordship will also consider vis-a-vis his individual right as a shareholder because his shareholding is going to be reduced. If this permission, lordship will also appreciate our situation. This is merely a permission. But this is merely a permission given by the Reserve Bank of India. Now, lordship will kindly imagine a situation before 2006.
Yes.
This permission existed. He was in control of that company. No shares were allotted to the respondent number 6. So it is entirely the decision of the company to allot shares based on the permission. So based on those, the company having withdrew from the writ petition, saying that it does not wish to proceed, and it could not have proceeded because of the reason of the Supreme Court judgment, because Supreme Court judgment clearly specifically mentioned that all the resolutions which were passed on a after a particular date would stand cancelled. And this writ petition which was filed by the company at the first instance was cancelled. May I just place 2 things, Your Lordship? The judgment of the Supreme Court for once on the aspect of the second-hand equipments. Volume 1 ta kache? Your Lordship will take the, I have filed the convenience compilation, the volume 1. In fact, this writ petition finds a mention in that order. Lordship will kindly come to page 38. Last 2 lines, Your Lordship. The sentence starting with the filing of, may I just read? The filing of repeated writ petition in the Calcutta High Court at the expense of the company. Your Lordship will mark the word company. The Supreme Court also recognized the writ petition against which the appeal has arisen was by the company, and Shojol was merely, the appellant was merely a director who has himself implemented him as a party, not in his individual capacity as a shareholder. Adversely affect the interest of the company. So it is the company's writ petition which has been acknowledged in this Supreme Court judgments also. And Supreme Court judgment in paragraph you will kindly come to page 18 once of that compilation. You will kindly come to paragraph 5. The hospital was inaugurated by Chief Minister of West Bengal on 24th of April 1995. Dr. Kamal Kumar Dotto contributed 4.26 crores, out of which equipments worth rupees 3.5 crores were brought from USA, and rupees 1.23 crores was contributed by Shojol Kumar Dotto. The grievance of Kamal Kumar Dotto was that he was denied shares of the company for the equipment brought by him by his younger brother Shojol Kumar Dotto. So Reserve Bank of India granted permission to allot shares in favor of Dr. Dotto on so and so, but the same was withdrawn on so and so at the instance of the company. The company filed a writ petition challenging the said approval of Reserve Bank of India before the High Court at Calcutta. The High Court directed to give personal hearing to the parties, and Reserve Bank of India and once again granted approval of the allotment of shares in favor of Dr. Kamal Kumar Dotto. The said approval was again challenged by the company by filing a writ petition before the High Court. Then again, some directions were not properly followed and another writ petition was filed by the company. Now, Lordship will see that this paragraph, all the writ petitions were filed by the company. It is an acknowledged fact in paragraph 5 itself by the Honorable Supreme Court. This is not a finding, this is a recording of facts, which has been recorded.
Yes.
May I have your Lordship's leave, madam, led by Mr.
Yes, please.
The outset, my lord, I apologize. I made a miss, my lord. In fact, I got another matter fixed, and my lord, that is why, my lord, I had to go there and say that kindly don't take it up.
Here it
I
was.
got that matter fixed, my lord, also.
Oh.
It was my fault, and my lord, sorry, I apologize, my lord.
No
It's a
apologies
continuing
required.
matter.
These things happen.
Now, my lord, my junior has placed before your lordships the Supreme Court order. Now, my lord, I shall proceed on the basis, my lord, what they have submitted on the question of maintainability first and then on merits, my lord. My lord, kindly take up, my lord, they first say that, my lord, the minutes of the meeting held on, my lord, 16th September 2006 was signed by both, but he did not consent to it. My lord, that does not, my lord, make the writ petition maintainable, my lord. Then they, my lord, rely on the writ petition which was filed. My lord, kindly, I have shown your lordships the writ petition. Some paragraphs, my lord, they have, my lord, relied on. May I show your lordships? The compilation, kindly take up, my lord, compilation page 40. Eta noy, tota. First, my lord, reliance has been placed on paragraph 1 at page 43. Kindly come to the first paragraph. The petitioner was incorporated on such and such, etc. Then next sentence, petitioner number 2 is the managing director and a shareholder of the petitioner number 1 and is vitally interested in the management and affairs of the petitioner number 1 and carries on business through the agency and instrumentality of the petitioner number 1. My lord, no whisper about his personal right otherwise or infringement of any of his alleged right. Now, my lord, they have relied on, kindly come to, my lord, page 128. Sure. ঠিক আছে। May I, my lord, paragraph 128. The respondent authorities in purporting to pass the said order dated 7th May 2004. Sorry, page 128, paragraph 128.
Yes.
The respondent authorities in purporting to pass the said order dated 7th May 2004 have acted arbitrarily and in hostile discrimination to the petitioners. Then next, my lord, kindly come to page 131. Sorry, Paragraph 131 at the bottom of that page. The respondent authorities in purporting to pass the said order dated 7th May 2004 have sought to impose unnecessary restriction on the petitioner's right to carry on trade and business and have sought to unjustly benefit the respondent number 6 at the cost and expenses of the petitioners. Next, my lord, kindly come to page 129. This page, paragraph, my lord, 137. The orders dated at the bottom of that page, my lord, page 129. The orders dated such and such are vitiated by bias on the part of the respondent number 2 against the petitioners. And kindly turn the page. Paragraph 138. The respondent number 2 in purporting to act as aforesaid acted in a manner so as to give rise to a reasonable apprehension of likelihood of bias on the part of the respondents against the petitioners. Then 140. The respondent authorities failed to take into consideration the documents filed on behalf of the petitioners with the respondent number 1 on the earlier occasion before the respondent number 5, though it was submitted on behalf of the respondent number 2 that all such documents and notes of submissions were being relied upon at the hearing held on such and such. In this connection, respondent authorities failed to take into account the report of SGS, the report of doctors, etc. Nothing personal. Then kindly turn the page, paragraph 141. The order dated 7th May 2004 has been passed with collateral object and improper motive to benefit the respondent number 6 at the expenses of the petitioners to unjustly enrich the respondent number 6. Then kindly come to my next page. Paragraph, I am not showing the particulars given. Kindly come to paragraph 142. In such circumstances, the petitioners being aggrieved by the 2 orders dated such and such hereby apply to this honorable court for the relief prayed for herein and to have the said orders quashed, set aside, declared illegal, etc. The grounds are set out. Now, my lord, as I have said, my lord, the entire writ petition does not anywhere say that, my lord, this order is affecting the personal right of the petitioner number 2. That is, my lord, not the case made out in the petition.
Yes, you said that there is no allegation that RBI permission is causing any prejudice to the writ petition. Petition number 2.
Yes. Now, my lord, next, my lord, they have, my lord, relied on, firstly, my lord, the order passed, my lord, by Justice Pal, my lord, in deleting the name of the company. In fact, I had shown that also before your lordships, my lord. The order dated 30th November 2006 at page 332, by which the name of the company was deleted.
Yes.
Now, my lord, this order was never challenged by him, by Sajul, the writ petitioner number 2. Page 332 of the compilation is the order of 30th November 2006. It was not challenged by Shojul. Immediately thereafter, my client had made an application for dismissal of the writ petition. My lord, kindly come to the next page, page 333. My lord, this was the application made by my lord Komul.
This was after the order of 30/11/2006.
Immediately thereafter, my lord, this application was made. Then, my lord, in paragraph 5, my lord, it speaks about the Supreme Court order of 11th August 2006. Then kindly turn the page. Paragraph 6, my lord, sets out the order. Then kindly come to page 339, paragraph 8. Pursuant to and in terms of the direction of the Honorable Supreme Court, a meeting was held on 16 September 2006. Your petitioner was elected as the managing director of the original petitioner number 1. Such meeting was inter alia attended by the petitioner number 2. In such meeting, it was resolved that the present writ petition be withdrawn. Such resolution is in the interest of the company. Then the minutes is annexed. Then, my lord, kindly turn the page, kindly come to paragraph 10. On 30th November 2006, the petitioner number 1 wanted to withdraw the aforesaid writ petition. By an order dated 30th November 2006, this Honorable Court was pleased to dismiss the writ petition as against the petitioner number 1, and direction was given that the writ petition be proceeded with as the petitioner number 1 as petitioner number 2 as the sole petitioner. Then kindly come to paragraph 11. Your petitioner states that independent of the petitioner number 1, the petitioner number 2 has no cause of action against any of the respondents in the instant writ petition. The instant writ petition, sorry, well, at page 3.
Yes, we have it.
Paragraph 11.
Yes.
Petitioner states that independent of the petitioner number 1, the petitioner number 2 has no cause of action against any of the respondents in the instant writ proceeding. The instant writ petition is not maintainable in view of the observations made by the Honorable Supreme Court of India. In the premises, it is just and proper that the instant writ petition be dismissed with cost with a direction upon the petitioner number 2 to pay such cost. Now, this was the application. An affidavit in opposition to it was filed, my lord, which is at page volume 12, page 1732. Lordship's got that.
Yes.
My lord, kindly come to, my lord, what does he say? They have, my lord, relied on page 1734, paragraph 3. I say that the facts and circumstances in which the writ petition was filed will appear from a copy of the writ petition, to which I shall crave leave to refer at the time of hearing. The statements contained in the said writ petition are true and correct. I say that I, along with Ruby, have filed the writ petition complaining of order dated 7th May 2004 passed by the respondent number 2 and communicated under cover of a letter dated 11th May 2004 issued by the respondents. I say that I, along with Ruby, also complained of arbitrary and wrongful acts of the respondents in the writ petition. Then kindly turn the page, paragraph 4. I say that at the instance of the respondent number 6, by an order dated 30th November 2006, this honorable court was pleased to delete from the list of the petitioners the name of the petitioner number 1. My lord, this is, my lord, it is contrary to the order, because the order would show, the order which I have placed would show that, my lord, the respondent number 1, my lord, or the petitioner number 1 had mentioned the matter. The matter was mentioned at the instance of the petitioner number 1, not at my instance. And direction was given that the writ petition be proceeded with by me as the sole petitioner. I say that in view of the order dated 30th November 2006, the relief spread for in the instant petition is barred by the principles of res judicata and estoppel. Well, nothing was decided. Prayer was made on behalf of the company that I do not intend to continue as a writ petitioner, delete my name. And that was done. There was no adjudication. By the principles of res judicata and estoppel, by judgment and or principles analogous thereto, I say that in view of the order dated 30th November 2006, I am entitled to proceed with the writ petition. Next, I say that the instant application is an abuse of the process of court. The application has been made without authority. I do not know why, and is not maintainable and is liable to be dismissed. The application is misconceived and is not maintainable in law. I say that the respondent number 6 has failed to disclose any reason as to why the writ petition is not maintainable. I have stated, my lord, categorically in paragraph 11 that on deletion of, my lord, the name of Ruby, the petitioner number 1, no cause of action survives. I say that I have a cause of action as against the respondents, and I am entitled to in law to proceed before the honorable court with regard to the arbitrary and illegal acts committed by the respondent authorities. Now, what cause of action? How the cause of action arose? There is no whisper either in the writ petition or in this affidavit in opposition. I say that I, along with companies under my control, hold substantial shares in Ruby, which the respondent number 6 is now wrongfully and illegally trying to dilute. No, that is not correct. With greatest of respect, my lord, that is not correct. That would appear from the order of CLB, which they have relied on. I shall now show it. I did not show it on earlier occasion. I say that I am also one of the founder, promoter and director of Ruby, the erstwhile petitioner number 1. I say that the shareholder and director, I am vitally interested in the management and affairs of Ruby, and I am entitled to in law to proceed with the writ petition. I say that facts and circumstances stated herein above will also be evident of the fact that wrongdoers are in control of Ruby. And have caused deletion of the name of Ruby with ulterior motive. That deletion was never challenged. Then paragraph 6. I say that the respondent number 6, along with one other shareholder, had instituted proceeding under section 397 and 398 of the Companies Act, alleging mismanagement and operation as against the then management of Ruby. I say that the said petition was numbered as CP number such and such. I say that the said proceedings was finally decided by an order passed by the Honorable Supreme Court on 11th August 2006. After the order of 11th August 2006, the respondent number 6 has sought to take control of Ruby. After taking control of Ruby, the petitioner wrongfully and illegally issued further equity shares of and in Ruby in favor of himself against the second-hand medical equipment caused to be imported by Ruby. While the petitioner was in control of the management of Ruby, the petitioner has thereafter committed several acts of illegalities and is acting against the interest and to the prejudice of Ruby and its shareholders, including myself. The petitioner is causing harm and loss to Ruby. Now, my lord, if these are allegations which, my lord, go directly under the domain of, my lord, the CLB, which he did. He challenged the actions before CLB, which was dismissed. 10F appeal is pending. Paragraph 7. I say that I am aggrieved by the order and the acts and conduct of the respondent authorities which are under challenge in the writ petition, and I have a right to pursue the instant writ petition and to pray for relief as prayed for in the writ petition. I say that the orders dated such and such of the respondent number 2 are liable to be quashed, set aside and declared illegal, null and void on the ground as mentioned in the writ petition, to which I shall crave leave to refer. Then, my lord, paragraph 8 starts dealing with this. Kindly come to directly, my lord, page 1748, my lord, where he deals with paragraph 11 and 12. Paragraph 14, kindly come to. With reference to paragraphs 11 and 12 of the application, it is denied and disputed that I have no cause of action against the respondents in the instant proceeding, or that I have no independent cause of action against the respondents as alleged or at all. It is denied and disputed that the instant writ petition is not maintainable in view of the observations made by the Honorable Supreme Court. I say that the subject matter of the writ petition or the reliefs prayed for in the instant writ petition were not in issue before the Honorable Supreme Court. It is denied and disputed that it is just or proper that the writ petition can be or should be dismissed, or with cost or with direction upon me to pay such cost as alleged or at all. Where is this cause of action? The case, my lord, which we find from the order impugned, my lord, was nowhere made out, either in the writ petition or in this affidavit in opposition. When my lord Sajol got a second opportunity to make out a case, he did not make out that case. The learned judge has proceeded. I have shown your lordships the order impugned. The learned judge has proceeded on the basis that this will affect his personal shareholding. My lord, this case is nowhere there. And this case could not have been there in this writ petition. Because, my lord, that is a matter which is the internal affairs of the company. You know, the facts, এই ফ্যাক্টগুলো দিয়ে কি হবে? না না, সময় নষ্ট হবে। Next, my lord, Reliance has been placed on the order of my lord Justice Ajoynath Ray of March 1999 to contend that, my lord, in the first writ petition, the right of the petitioner number 2 was acknowledged. My lord, with greatest of respect, my lord, that is not the order. My lord, the order is at page 225 of the compilation. I have placed that order, my lord, possibly even on the last occasion. Only one paragraph may I show, my lord, page 227. My lord, effectively third paragraph, the respondent number 3, page 227. The respondent number 3 shall grant a personal hearing to the writ petitioners. My lord, the no court, my lord, says that, my lord, when there are two writ petitioners, one is espousing the cause of the company, my lord, the court nowhere says, my lord, the hearing would be given to the petitioner number 1 only. It's mentioned it will be, hearing would be granted to the petitioners and the respondent number 4 or their duly authorized advocates and etc. My lord, that is all, my lord. It has also been alleged that I have not challenged this order. But I was not required to challenge the order. The writ petition was there. We knew what was there in the writ petition. We proceeded on that basis. One more paragraph, my lord. Kindly come to page 226 once. আর কি বাকি রইল? My junior wants me to start from, my lord, page 225, last paragraph. There are allegations and counter allegations to the effect that the equipment transmitted from USA was good and usable. And on the other hand, it is alleged that those have not proved to be of such use. There is some proved to be of much use.
Much use, yes.
There is some statement on record that after large-scale repairs, some equipments could be used. Without the approval of the Reserve Bank of India, the issue of shares cannot go through. Thus, whatever decision the company law board or any other appropriate authority might take on the merits of the issuance of shares, the first hurdle requiring the Reserve Bank permission has to be crossed in any event. In the writ court, I am not concerned with the factual dispute and the value or usability of the machine imported into India. This court is concerned with the validity and reasonableness of the orders passed by Reserve Bank functioning within the four corners of the law. That is all. Then, my lord, the next order, it may come back to your lordship's mind that on the basis of this order passed by this honorable court, my lord, the executive director of Reserve Bank, my lord, who was really, my lord, the person, he had, my lord, decided the issue. They participated. When they did not succeed, they filed another writ petition, saying that Justice Ray's order directed the general manager to pass the order, but the general manager did not do that. On the contrary, the executive director has done that. Now, my lord, that writ was allowed, and again it was sent back to the Reserve Bank of India. When, my lord, which culminated in the orders, my lord, challenged in this writ petition. My lord, kindly once come to page. কেন 332 টা কেন লেখা হচ্ছে? Oh. Now, on maintainability, my lord, certain decisions have been, my lord, relied on. May I show those decisions and try to distinguish? ওই জাজমেন্টের কম্পাইলেশন গুলো আছে না, জাজমেন্টের দিয়েছে মোটা মোটা দুটো দুটো না একটা একটা দুটো ও সরি হ্যাঁ দুটো তাতেই আছে
ঠিক আছে দেখুন হ্যাঁ
27 অব্দি কত লাস্ট পেজ কত আছে একটু দেখি হ্যাঁ তাহলে ওই একটা করেই বলা আছে Well, at the first judgment which they have relied on to contend that, my lord, the writ petition is maintainable, is reported in AIR 1970 Supreme Court, page 564. My lord, that is, my lord, at page 239 of the compilation. R.C. Cooper versus Union of India. Well, let kindly come to page 255. They have relied on paragraphs 13, 14, 15, and 19. Before going to those paragraphs, may I rely on, my lord, paragraphs 1, 6, and 7? Kindly come to the first paragraph at page 255. Lordship got it. Rustamji Kavasji Cooper, hereinafter called the petitioner, holds shares in the Central Bank of India, the Bank of Baroda, and the Bank of India Limited, and has account, current, and fixed deposit with those banks. He is also a director of the Central Bank of India Limited. By this petitions, he claims a declaration that the banking company's acquisition and transfer of undertaking ordinance promulgated on such and such, and the banking company's acquisition and transfer of undertakings act 1969, which replaced the ordinance with certain modification, impair his right guaranteed under Article 14, 19, and 31. His right and are on that account invalid. Now kindly come to paragraph 6. Next page, madam, page 256. Lord, paragraphs 5 speaks of, my lord, State Bank of India Act. Then kindly come to paragraph 6 on the left-hand column. Later in the afternoon of July 19, 1969, which was a Saturday, the Vice President acting as President promulgated in exercise of the power conferred by Clause 1 of Article 123 of the Constitution, Ordinance 8 of 1969, transferring to and vesting the undertaking of 14 named commercial banks in corresponding new banks set up under the ordinance. The long title of the ordinance reads as follows. An ordinance to provide for the acquisition and transfer of the undertakings of certain banking companies in order to serve better the needs of development of the economy in conformity with national policy and objective, and for matters connected therewith or incidental thereto. Then, my lord, section 2 is quoted, my lord. Kindly omit that. Kindly come to the next page. Paragraph 7. The principal provisions of the ordinance were: 1. Corporation styled in the ordinance corresponding new banks shall be established, each such corporation having paid up capital equal to the paid up capital of the named bank in relation to which it is a corresponding new bank. The entire capital of the new bank shall stand vested in the central government. The corresponding new banks shall be authorized to carry on and transact business of banking as defined in Clause B of Section 5 of the Banking Regulation Act 1949, and also to engage in one or more forms of business specified in subsection 1 of Section 6 of that Act. The chairman of the named bank holding office immediately before the commencement of the ordinance shall be the custodian of the corresponding new bank. The general superintendence and direction of the affairs and business of a corresponding bank shall be vested in the custodian, who shall be the chief executive officer of that bank. So, my lord, the businesses were taken over. And that is where, my lord, it had Hart, R.C. Cooper, and, my lord, similarly placed people. Now, kindly come to paragraph 13, on which Reliance was placed. At page 259 at the bottom. A company registered under the Companies Act is a legal person, separate and distinct from its individual members. Property of the company is not the property of the shareholders. A shareholder has merely an interest in the company arising under its article of association, measured by a sum of money for the purpose of liability and by a share in the profit. Again, a director of a company is merely its agent for the purpose of management. The holder of a deposit account in a company is its creditor. He is not the owner of any specific fund lying with the company. A shareholder, a depositor, or a director may not therefore be entitled to move a petition for infringement of rights of the company unless by the action impugned by him, his rights are also infringed. By a petition praying for a writ against infringement of fundamental right. Now, my lord, this was, my lord, guaranteed at that point of time under Article 19(1)(f), which had, my lord, subsequently been removed. Infringement of fundamental right, except in a case where the petition is for a writ of habeas corpus and probably for infringement of guarantees under Article 17, 13, and 24. The petitioner may seek relief in respect of his own rights and not of others. The shareholder of a company, it is true, is not the owner of its assets. He has merely a right to participate in the profits of the company, subject to the contract contained in the Articles of Association, but on that account, the petitioner will not fail. A measure, executive or legislative, may impair the right of the company alone and not of its shareholders. It may impair the right of the shareholders and not of the company. It may impair the right of the shareholders as well as of the company. Jurisdiction of the court to grant relief cannot be denied when, by state action, the right of the individual shareholder are impaired if the action impairs the right of the company as well. The test in determining whether the shareholder's right is impaired is not formal. It is essentially qualitative. If the state action impairs the right of the shareholders as well as of the company, the court will not concentrating merely upon the technical operation of the action deny itself jurisdiction to grant relief. Then, my lord, they have relied on 15. The petitioner claims that by the act and by the ordinance, the rights guaranteed to him under Article 14, 19, and 31 of the Constitution are impaired. He says that the act and the ordinance are without legislative competence in that they interfere with the guarantee of freedom of trade and not made in the public interest. That the parliament has no legislative competence to enact the act, and the president had no power to promulgate the ordinance because the subject matter of the act and the ordinance is partially at least within the state list, and that the act and ordinance are invalid because they vest the undertaking of the named banks in the new corporation without a public purpose and without setting out principles and the basis for determination and payment of a just equivalent for the property expropriated. He says that in consequence of the hostile discrimination practiced by the state, the value of his investment in the shares is substantially reduced. His right to receive dividend from the investment has ceased, and he has suffered great financial loss. He is deprived of his right as a shareholder to carry on business through the agency of the company, and that in respect of the deposits, the obligation of the corresponding new bank, not of his choice, are substituted without his consent.
So you are saying he has made substantial
Personal grievance.
grievance.
Absolutely. That he will not get, he is deprived of his business, everything.
Yes.
In fact, this paragraph, my lord, I thought, my lord, helps me. And the last paragraph they have relied on in this judgment is paragraph 19. Kindly come to the next page. It is not necessary to consider whether Article 31A 1D of the Constitution barred the petitioner's claim to enforce his right as a director. The Act prima facie does not, though the ordinance purported to seek to extinguish or modify the right of the petitioner as a director to seek to take away expressly the right of the named banks to carry on banking business without reserving their right to carry on business other than banking, etc. These are again, my lord, personal rights.
Yes.
The next judgment, my lord, on the same point which they have relied on is reported in AIR 1973 Supreme Court 106 at page 321 of the compilation. But they have relied on paragraph 22, but before that, my lord, kindly come to paragraph 1. At page 325. Page 325, paragraph 1. These petitions challenge the import policy for newsprint for the year April 1972 to March 1973. The newsprint policy is impeached as an infringement of fundamental right to freedom of speech and expression in Article 19(1)(a) and the right to equality in Article 14 of the Constitution. Some provisions of the newsprint control order 1962 are challenged as violative of article such and such of the Constitution. Now kindly come to next, my lord, paragraph 7. Next page. What do they say? Paragraph 7. The newsprint policy said to be discriminatory and violative of Article 14 because common ownership units alone are prohibited from starting a new paper or a new edition of the same paper, while other newspapers with only one daily are permitted to do so. The prohibition against interchangeability between different papers of the same unit and different editions of the said paper is said to be arbitrary, irrational, because it treats all common ownership units as equal and ignores pertinent and material differences between some common ownership units as compared to the others. The 10-page limit imposed by the policy is said to violate Article 14 because it equates newspapers which are unequal and provides the same permission page limit for newspapers which are essentially local in their character and newspapers which reach larger section of people by giving world news and covering large fields. 20% increase allowed for newspapers whose number of pages were less than 10 is also challenged as violative of Article 14 by discriminating against newspapers having more than 10 pages. The difference is entitlement between newspapers with an average of more than etc. Now kindly come to next. Paragraph 20 before I go to paragraph 22 relied on by them. Paragraph 20. It relies on my lord R.C. Cooper.
Yes.
Kindly come to my lord the right hand column, my lord, about 5 lines from the top. The petitioner there was a shareholder, a director, and holder of deposit of current account in the bank. The locus standi of the petitioner was challenged on the ground that no fundamental right of the petitioner there was directly impaired by the enactment of the ordinance and the act of any action taken thereunder. The petitioner in the bank nationalization case, that is my lord R.C. Cooper, claimed that the rights guaranteed to him under Article 14, 19, and 31 of the Constitution were impaired. The petitioner's grievances were this: the act and the ordinance were without legislative competence, the act and the ordinance interfered with the guarantee of freedom of trade, etc. He was deprived of the right as a shareholder to carry on business through the agency of the company. This is how my lord R.C. Cooper is summarized. And then they rely on paragraph 22 again. At the bottom of that page. Bank nationalization case. This court held the statute to be void for infringing the right under Article 19(1)(f) and 19(1)(g) of the Constitution. In the bank nationalization case, the petitioner was a shareholder and a director of the company which was acquired under this statute. As a result of the bank nationalization case, it follows that the court finds out whether the legislative measure directly touches the company of which the petitioner is a shareholder. A shareholder is entitled to protection of Article 19. That individual right is not lost by the reason of the fact that he is a shareholder of the company. The bank nationalization case has established the view that the fundamental rights of shareholders as citizens are not lost when they associated to form a company. We're not pausing here for a moment. The order passed by the Reserve Bank, my lord, in no way affected the right of the company. My lord, kindly appreciate the order. My lord, I could have understood that it was a direction. It was not a direction. It was a partition.
It enabled the company.
The company could have said, no, I do not repay. It said, it tried to say till it was under the control of Shadul. But there are, again, my lord, at the sake of repetition, my lord, there was no direction from Reserve Bank. A simpliciter partition. Next, my lord, when their fundamental rights as shareholders are impaired by state, there is no question of any fundamental right of my lord Shajul being impaired by the action of my lord Reserve Bank of India. At least no such case has been made out. Their rights as shareholders are protected. The reason is that the shareholders' rights are equally and necessarily affected if the right of the company are affected. The rights of shareholders with regard to Article 19(1)(a) are projected and manifested by the newspapers owned and controlled by the shareholders through the medium of the corporation. In the present case, the individual right of freedom of speech, etc. not required. আর কিছু দেখাবার আছে না না সেটা তো পরে এটাতে না না এই জাজমেন্টটাতে Now, my lord, the next judgment they have relied on is reported in AIN 1973 Supreme Court page 602. It's at page 369 of the compilation. They have relied on, my lord, paragraphs 44 to 46. My lord, before going into those paragraphs, my lord, may I show some paragraphs which gives the facts?
Yes.
Kindly come to page 370. First two paragraphs. This petition challenges the application of the General Insurance Emergency Provision Ordinance 1971, the General Insurance Emergency Provision Act 1971, as well as the General Insurance Emergency Provision Amendment Act 1972 to the petitioner company. The petitioners are three in number, namely the company and two directors and shareholders. The petitioners asked for a declaration that the order dated 13th May 1971 made in exercise of the powers conferred by Section 4(1) of the General Insurance Emergency Provision Ordinance 1971 and the direction dated 13th May 1971 given by virtue of the powers conferred by Section 4(3) of the General Insurance Act are illegal. Now, let's kindly come to paragraph 13. May 1971, the General Insurance Emergency Provision Ordinance 1971, referred to as the ordinance, was promulgated. On 13th May 1971, an order under Section 4(1) of the ordinance was made by the central government appointing respondent number 2 as the custodian of the company. On the same day, directions were given by the central government under the ordinance in regard to the management of the undertaking of the company. On 17 June 1971, the General Insurance Emergency Provision Act 1971, referred to as the Act, was enacted. The Act replaced the ordinance. The Act was retrospectively brought into force with effect from 13th May 1971. The ordinance as well as the Act contain similar provisions. Now, kindly come to my lord, next page, next paragraph. The purpose of the aforesaid legislative measures was to provide for the taking over in the public interest of the management of general insurance business, pending nationalization of such business. By general insurance business, it meant under the Act, fire, marine and miscellaneous insurance business, whether carried on singly or in combination with so and so. One or more of them, but does not include capital redemption business and annuity business. An insurer under the Act means an insurer as defined in the Insurance Act 1938, referred to as the Insurance Act, who carries on general insurance business in India and includes all insurers whose registration under the Insurance Act has not remained wholly cancelled for a period of 6 months immediately before the appointed date. Undertaking is defined by the Act to mean in relation to an insurer incorporated outside India, the undertaking of that insurer in India. Then, my lord, kindly come to the right-hand column, paragraph 19. The crucial provisions are Section 15A of the Act. It is enacted that nothing contained in this Act shall apply to any insurer whose business is being voluntarily wound up or is being wound up by court. The petitioner, strongly relying on Section 15A of the Act, the petitioner alleges that the business of the company was being voluntarily wound up at all material times within the meaning of the ordinance and the Act. Therefore, the petitioners contend that the company is not within the mischief of these legislative measures. And then, my lord, kindly come to paragraph 44. At page 377. The government contended that the petitioner company could not invoke fundamental rights. Apart from the company, the other petitioners are 2 shareholders and directors. In R.C. Cooper, which is referred to as the bank nationalization case, the petitioner fulfilled 3 capacities. He was a shareholder, a director, and a holder of deposit of current account in the bank. The locus standi of the petitioner was challenged in the bank nationalization case on the ground that no fundamental right of the petitioner was directly impaired by the ordinance or the Act or any action taken thereunder. The petitioner in that case claimed that the rights guaranteed under Article 14, 19 and 31 of the Constitution were impaired. The ruling of the court in bank nationalization was thus, then kindly turn the page, paragraph 45. It follows that the court finds out whether the legislative measure directly touches the company of which the petitioner is a shareholder. A shareholder is entitled to protection of fundamental rights. The individual rights of a shareholder is not lost by reason of the fact that he is a shareholder. The reason why the shareholders' fundamental rights are protected is that when their fundamental rights as shareholders are impaired by state action, the court applies the qualitative test on the ratio that the shareholders' rights are equated to and correspond to the right of the company. The shareholders own the property through the company. The shareholders carry on business through the medium of the company. The shareholders' investment in the shares is affected by the state action or the legislative measure. In the bank nationalization case, this court said that the courts will not, concentrating merely upon the technical objection to the action, deny itself jurisdiction to grant relief to shareholders when the right of shareholders as well as of the company are impaired. The locus standi of the petitioners cannot be challenged. For this reasons, the petitioners succeed, there will be an order, etc. Now again, my lord, it said that, my lord, about the personal rights of the shareholders through the
No such case has been made out.
and nothing has happened really. Now, my lord, kindly appreciate another thing, my lord. Today, after I really, my lord, I was wondering, I was thinking that, my lord, after the Supreme Court order of 2006, passed in the matter, my lord, arising out of the operation mismanagement case filed by my lord Kamal, the orders passed, the order passed by the Supreme Court, setting aside everything, and my lord, subsequent steps which have been taken on the basis thereof. Any order would really, my lord, nullify that Supreme Court order. Supreme Court has said that Kamal ought to have been a managing director, shares ought to have been given, and, my lord, the earlier meetings were set aside. Kamal was allowed to, my lord, hold a meeting, preside the meeting. On that basis, my lord, steps were taken. And Kamal, as on date, my lord, is holding, my lord, the position of, my lord, the manager. Now, today, my lord, as I have said, I was wondering, my lord, that effect of, my lord, what has been prayed for in the writ petition is nullifying, my lord, the Supreme Court. Now, my lord, the next decision relied on is reported in AIN 1974 Supreme Court once. না কেন কোথায় Well, For me also.
So what you want to say is that your objection is not on the point that he's a shareholder. Even though he is a shareholder, he must make out a case, which he has not done. No personal injury or prejudice has been made out. And therefore, these decisions which are being relied upon.
All these decisions speak about personal.
Yes. To the extent that they say that shareholders does not lose his rights, there is no argument. The point is, what is the right that he's trying?
And my lord, I'm not citing any decision, my lord. That case has to be made out, my lord. The case
Correct.
which the learned judge, my lord, has proceeded on the basis that, my lord, it affects his were made out. But the next two decisions they have relied on, my lord, is the first one is reported in AIN 1974, Supreme Court 1044. That is, my lord, at page 386 of the compilation.
They have referred to paragraphs 8 and 9.
8 and 9. Yes. My lord, kindly, I am not very certain, my lord, so far as your lordship's copy is concerned, my lord, kindly come to page 387.
Yes.
I made a mistake. 387, my lord, it ends with index note number F.
Yes, correct.
Then, my lord, next page 388. My lord, that is, my lord, Supreme Court's page 1045 at the top.
No, next page is 1048.
Yes, pages are missing. Yes. I just forgot to tell my lord to get copies. May I read out only one paragraph?
You tell us, we'll follow the paragraph. If there is no difference in the paragraph.
Paragraph 1 I shall read out, which is not here.
All right.
I shall, my lord, in course of day, I shall try.
Oh, it is not. Oh, there is a missing page.
3 pages are missing.
But 1045 is at page 387.
Yes.
And your
My lord,
6 and 7 are 46 and 47 are missing. 46 and 47 are missing.
1046 and 47 are missing. SCC no, no. No.
Can you give us in that? You have it in the paragraph. No, you read from that. Whatever you are comfortable with, you use.
AIR 74 Supreme Court 1044. Can the AIR print? SCC no. So, is there.
Yes, we are trying to get it.
I can airdrop it.
Yes. We are on.
By airdrop, my lord, I only understand that during flood, my lord, reliefs are airdropped. Nothing further. Kindly come to the first paragraph. Then I shall go to their paragraphs 8 and 9. The appeal and the writ petition number such and such are by Press Trust of India, while writ petition number such and such is by the Indian National Press Bombay Limited. The appeal and the writ petitions challenge the order dated 27th October 1967, issued by the first respondent, the Union of India, Ministry of Labour, Employment and Rehabilitation, Department of Labour and Employment, accepting the recommendations of the Wage Board constituted under Section 9 of the Working Journalist Conditions of Service and Miscellaneous Provisions Act 1955, hereinafter referred to as the said Act, as violating Article 14, 19 and 31 of the Constitution of India. The order accepting the recommendations in respect of the wages, scales of pay, etc. of the working journalists was subject to certain minor modifications therein specified, being modifications which in the opinion of the central government did not affect important alteration in the character of recommendation. The second respondent is the Indian Federation of the Working Journalists. The interest of the working journalists were being affected by these provisions. And then kindly come to paragraphs 8 and 9. Insofar as the contention that no relief in the writ petition is available under Article 19 is concerned, it is urged that the prayer for substitution of so and so, a shareholder in the first petitioner company in place of the deceased, so and so in writ petition number such and such, and of Sri K. Narendra, a shareholder in the first petitioner company in place of Sri Umashankar Dikshit, in writ petition number 40 of 1968 being manifestly just, should be granted. If these prayers are granted, the second petitioners in the respective two writ petitions can also challenge the impugned order under Article 19. It may be mentioned that in the first petition, the substitution is necessitated by the death of the second respondent, and in the second, as Sri Umashankar Dikshit has been appointed a central minister, another shareholder is sought to be substituted. It is contended on behalf of the second respondent that these petitions should not be allowed, nor should the petitioner's advocate be permitted to raise any question of infringement of the rights conferred under Article 19, nor is it right to say that no question of limitation arises in the matter of enforcement of fundamental rights. It is also submitted that even otherwise a shareholder can enforce only his rights under the law, and no such infringement can arise in this case. It appears to us that though it may be that no specific mention has been made in the petitions of any of the articles which are alleged to have been infringed by the impugned order, the facts stated and the contentions urged in the petition entitle the petitioners to invoke Article 19. Kindly take note, my lord, the facts stated and the contentions urged in the petition entitle the petitioners to invoke Article 19. A shareholder can challenge the order if the restriction on his right under Article 19(1)(f) is unreasonable. If the impugned order places a heavy burden on the resources of the company, or the wages has been fixed without taking into consideration the capacity to pay, or where the higher wages than what the journalist asked for is fixed without hearing the employers, then that burden will affect the shareholders also. In such a case, it will not be valid to contend that the right of a shareholder is not infringed. We think that the petitioner can validly challenge the order under Article 19. Then paragraph 9. Even if we reject the prayer in the second petition, in CMP number such and such, as there is nothing to debar a central minister from continuing to be a petitioner, the petitioners cannot be denied relief under Article 19. Similarly, if we reject the prayer in the first petition on a technical plea that the second respondent having died, no relief can be granted under Article 19, there is nothing to prevent another writ petition being filed by a shareholder of the first petitioner company challenging the impugned order under Article 19. The rejection of the prayer, therefore, will merely prolong the litigation. The argument that such a petition would be barred by limitation cannot be considered unless the circumstances under which a fresh petition has been filed and the question whether the petitioner has been guilty of laches or tried to pursue his remedy diligently are examined. It may be that the circumstances urged for filing the petition later may justify it being entertained. In our view, as the prayer for the substitution in each of the writ petitions will further the interest of justice, and as the balance of convenience would justify, the substitution was allowed. Well, again, my lord, it proceeded on the basis of 19(1)(f), which is no more there. In any event, my lord, it shows, my lord, how the interest of the shareholders was being could have been affected, which is not the case here. And my lord, the last one on this, এটাই তো last 2004-এরটা না আর কিছু দেখিয়েছিল? হ্যাঁ হ্যাঁ 4-9 কি হচ্ছে? The last one is, my lord, relied on is reported in 2004, volume 9, Supreme Court cases, page 438. My lord, that is at page 400. Kindly come to page 400. Only one paragraph they have relied on, my lord. I shall show that, and my lord, they have relied on paragraph 18. Kindly come to, my lord, paragraph 18, which is at page 412. May, page 412. It is difficult to subscribe to the view propounded by the learned counsel for the appellants. As stated earlier, the order of amalgamation is based on a compromise or an arrangement arrived at between the two companies. No individual living being owns the company. Each shareholder is the owner of the company to the extent of his shareholding. By enacting section 391 to 394, a method has been devised to give effect to the will of the prescribed majority of shareholders creditors. Even in the absence of individual agreement by all the shareholders and creditors, the decision of the majority prescribed in section 391(2) binds all the creditors and the shareholders. The scheme, after being sanctioned by the court, binds all its creditors, members, and shareholders, including even those who were opposed to the scheme being sanctioned. It binds the company as well. While exercising its power in sanctioning the scheme of amalgamation, the court is to satisfy itself that the provisions of statute have been complied with, that the class was fairly represented by those who attended the meeting, and that the statutory majority was acting bona fide and not in an oppressive manner, that the arrangement is such as which a prudent, intelligent, or honest man or a member of the class concerned and acting in respect of the interest might reasonably take. While examining as to whether the majority was acting bona fide, the court would satisfy itself to the effect that the affairs of the company were not being conducted in a manner prejudicial to the interest of its members or to public interest. The basic principle underlying such a situation is none other than the broad and general principle inherent in any compromise or settlement entered into between the parties, the same being that it should not be unfair, contrary to public policy, and unconscionable or against the law. এই প্যারাগ্রাফটা কি শুধু দেখতেছি? কেন এটা কিসের জন্য দেখিয়েছি? My lord, really, my lord, according to me, my lord, it's not on the question of maintainability, my lord.
Is submitted based on this judgment is that every shareholder owns the company. That is the point he wanted to make by reading this paragraph 18.
Here, it's nobody's case, my lord. Nothing was demonstrated that by the order of, my lord, the Reserve Bank, the company suffered.
So therefore, if we have understood correctly, to that extent, you are not joining an issue. A shareholder having a locus. But the point is, what is the prejudice being caused to that shareholder? That has to be made out, which they have not done.
Firstly, my lord, he proceeded on the basis of the company. And when the name of the company was deleted, my lord, they ought to have said that this is how, in my restricted submission, my lord,
Yes.
this is how the personal right of shareholder
In the changed circumstances, what is there?
was affected. There is
Because he laid emphasis on this line. Each shareholder is the owner of the company. So he was saying
to
that
the extent of his shareholding, yes. Now again, my lord, Supreme Court order could not have affected the right of the company. As I have already submitted, the company could have said, no, I will not issue the shares. That's it. Not it. It was saying, it could have continued to say. Now, my lord, the next point is on merit. My lord, lordships have seen, my lord, the Supreme Court order of 2006. Shit. Maintainability তে কোনো judgment নেই। না ওদের See, my lord, I had, my lord, relied on the Supreme Court judgment that arose out of a, my lord, company proceeding initiated by my client, Komal, alleging, my lord, oppression and mismanagement against, my lord, the company, and particularly that was the allegation. It was heard by the company law board. Company law board, my lord, granted relief to my client. Then, my lord, it went before this, it came up before this honorable court, and ultimately it went before the honorable Supreme Court. I have placed the order of the honorable Supreme Court extensively. Which I did not place, my lord, is the order of the company law. My lord, they have placed few paragraphs, but I would like to place, my lord, few more paragraphs of, my lord, the company law board judgment, my lord. My lord, kindly, my lord, this company law board judgment starts in volume 15. 15 or 16.
Can you give
Let-
us the page, please?
Yes, my lord. It starts at page 179. But lordships need not, my lord, bother about that, my lord. Kindly come to the volume 16. Starts at page 179, the order of CLB.
That would be in 15. 179 would be in 15.
Volume 15.
But we are referring to the portion which lies in 16.
No. Submission leaking. Let kindly come to page 211. But my lord, 212, my lord, that is, my lord, the typed version. Lordships can take that also.
Paragraph 20.
Paragraph 20, yes. Because I am not, my lord, showing your lordships in submissions.
Yes, yes.
We have considered the pleadings and arguments of the counsel. Before considering the merits of the case, it is essential to examine the status of the petition, whether he is a collaborator or an NRI investor or the chief promoter, as the determination of the same is necessary to decide the issue before us. We have on record the memorandum and articles of the company. The petitioner is shown as one of the signatories as well as one of the first directors of the company. These documents are dated
Sometime in 1991.
1991. In the application made to SIA, dated 31st May 1993, it is stated that the hospital was to be established with the participation of the petitioner and that imported equipment worth rupees 420 lakhs would be purchased from the foreign exchange provided by the NRI doctor. The cost of the project was indicated at rupees 1100 lakhs and rupees 900 lakhs as the authorized capital, out of which rupees 800 lakhs would be the NRI participation. Under the heading Foreign Investment Financial Collaborator, the name of the petitioner is mentioned. In the abridged project report enclosed with the application, it is mentioned that the petitioner was the principal promoter and the other promoter being the respondent, a resident Indian. Under the means of finance, it is mentioned that NRI investment would be rupees 800 lakhs, comprising of such and such, such and such. Then, my lord, kindly come to page 214, my lord. I am omitting, my lord. I would place, my lord, the relevant portion, the portions which according to me are relevant. My lord. Page 214. About, my lord, 10, 11, 12 lines from the top. Lordships would find, my lord, SIA, RBI in bold.
Yes.
After that, it is also stated therein that import of capital equipment, etc., would be allowed as per the import policy prevailing from time to time. On receipt of this approval, the company sought for two amendments, namely such and such. Well, these are again not required. Well, kindly come to 1-6. About, my lord, 5 lines from the bottom. the usual address, the sentence starting with the usual address.
Yes.
The usual address of the petitioner is in USA, as is evident from the application made by the company to CR at page 54 of such and such. And in the annual return made up to 31st December 1996, the addresses of the petitioner directed have been indicated as in USA. It is therefore evident that the respondent companies were aware that the usual residents of the petitioner are in USA. Perhaps as rightly pointed out by so-and-so, this article has been framed different from the provisions of section 286, according to which notices are to be issued at the usual address of the directors in India. Therefore, we are of the view that the notices issued at the local address in India cannot be considered to meet the provisions of Article 121A. Even otherwise, we find from copies of notices at R11 that in respect of the second petitioner, the address shown is P.O. Hirapur District, Dhanbad, Bihar. And in respect of most of the meetings, the time gap of alleged date of posting and the date of meeting, considering the nature of the address given, the transit time itself is likely to take a few days. Then, my lord, kindly omit those dates, etc. Then, in respect of the petition, the notices are addressed to a local address, notwithstanding the fact that the company itself has attached various documents as Annexure R20, indicating that the petitioner used to stay in some hotel or guest house during his visit to Calcutta. Thus, we find, even assuming that the notices are to be sent to local addresses in India, yet the company has not ensured that adequate time is given and that the notices are sent to proper addresses. In equity also, we find that the action of the company to have posted notices for the meetings to local address of the NRI directors lacks in probity and fair play, as the petitioners being not only the first directors of the company, but also substantial holders of shares, they should have been given notices to their addresses in USA. Accordingly, we hold that no notices for the board meeting should be deemed to have been given to the petitioners. In view of this finding, we do not propose to examine whether the notices were genuine, etc. Then, my lord, kindly come to page 220 at the top. First line. In view of our finding that page 220.
Yes.
View of our finding that no notices should be deemed to have been served on the petitioner directors for the board meetings. The decisions taken in these board meetings, granting that they had taken place, should be declared to be null and void, as general proposition of law is that proceedings of board meetings without notices, original copy থেকে পড়,
To a director.
to a director cannot be recognized. If so, then the alleged vacation of office by the petitioner director, as well as the allotment of shares, as also the decision taken in the board meeting for not applying to RBI for allotment of shares, which are the main allegations the petitioners, would also become null and void. However, since arguments advanced in respect of all these allegations, we shall deal with the same. Regarding vacation of office, copy. Regarding vacation of office by the petitioner director, the learned counsel argued to state that directorial complaints cannot be agitated in a 397-398 petition, while as a proposition it is so in normal circumstances. Yet in cases of family companies or companies in the nature of partnership, depending on the facts of the case, directorial complaints have been adjudicated by us in 397, 398 proceedings. In the present case, the petition is a composite petition wherein not only directorial complaints are made, but also complaints relating to conversion of majority into minority. Further, when the principal promoter having high stake in the company complains of his exclusion from the management, we feel that equity demands that his complaint should be inquired into in the present proceedings. The learned counsel also submitted that since the advocate for the petitioner had informed the company respondent by a later date such and such that the dispute between the parties had been amicably settled, the petitioner cannot agitate at this point of time issue of shares and change in management. Even assuming that the petitioner had authorized this advocate to send that letter, which is disputed by the petitioner, the circumstances have changed afterwards. Further, additional shares were issued. The petitioner directors were declared to have vacated their office and allotment of shares against the cost of imported equipment denied. In the changed circumstances by which the petitioners have been completely ousted from the company, which was not the position when the letter from the advocate of the petitioner was written, we do not think that it would be right to bind the petitioner to the terms of the said letter. Regarding vacation of office by the second petitioner, the company has applied the provision of section 283(1)(g) on the ground that this petitioner had never attended any board meeting right from corporation of the company in spite of notices. Now, 283(1)(g) lordships are aware that if my lord a director does not attend 3 consecutive meetings, he goes. But here, my lord, there are cases that from the incorporation he did not, my lord, attend any meeting. We have already held that neither in law nor in equity it could be considered that due notices had been issued to the petitioners to invoke the provisions of section 283(1)(g). Even otherwise, we find that the company had not taken the stand that he had vacated the office when notices for the AGM convened on 30th December 1996 was issued, wherein re-election of this petitioner was an item in the agenda, wherein it was stated to appoint directors in place of Dr. Vinod Sinha and Dr. S.K. Ghoshal, who retire by rotation and being eligible offer themselves for reappointment. The resolution passed in that meeting reads, resolved Dr. Vinod Sinha, who retires by rotation at this meeting, is not being reappointed as his eligibility for reappointment has already ceased for not attending any board meeting of the company and his lack of active interest, etc. Then, my lord, it was again kindly come to, my lord, page 224. It was also not accepted. I am omitting that, but it was also not accepted by the company law book. Then kindly come to page 224, paragraph 25. In regard to the vacation of office by the petition, the provisions of the same section 283(1)(g) were invoked. As per the form number 32 filed with the Register of Companies, the date of vacation of office by the petitioner was 24th February 1997. Even though, if the contention of the respondent that the petitioner had not attended any meeting after 16th April 1996 is correct, he would have ceased to be a director much earlier. This form number 32 was filed on 14th March 1997. The company is purported to have informed the petitioner that he had vacated the office by a letter dated 3rd March 1997, the receipt of which is denied by the petitioner. It is on record that the petitioner had convened a board meeting on 3rd March 1997 at 11 a.m. and was attended by the directors. It is not clear as to at which time on that day a letter was issued indicating therein that the petitioner had vacated his office. If it had been written before 11 a.m., then the respondent should have been aware of it and should have refrained from attending the said meeting. If the letter was written after the meeting, then the only conclusion that we could come to is that it was only with a view to nullify the board meeting on that day. Therefore, we do not believe that the same letter dated 3rd March 97 was sent to the petitioner and that the stand had been taken only to nullify the validity of the meeting convened by the petitioner on the ground that he had no locus standi to convene and hold the meeting. The meeting held by the petitioner assumes importance in view of the fact that in this meeting, according to the petitioner, a resolution was passed to apply to RBI for allotment of shares to all. The NRI whose contribution remained as share application money, including allotment of shares for the second-hand equipment. Again, it is not clear to us as to why the date of 24th February 97 was assumed as the date of vacation of office, as he would have vacated his office by operation law as early as in July 1996. Therefore, we are inclined to agree with the contention of the counsel for the petitioner that the petitioner was shown to have vacated his office on 24th February 1997 only with a view to nullify the proceedings on 3rd March 1997. Then, my lord, kindly come to page 227. Paragraph 27. In regard to allotment of shares against the value of imported equipment, the major objection of the respondent are neither the approval of SIA nor the RBI covers allotment of shares against import of equipments. The company was never aware that the equipments were second-hand. As per import policy, second-hand equipment cannot be imported. There is no contract or agreement in terms of section 75(1)(b) for allotment of shares other than for cash. The equipments were outdated, overpriced, and unusable, and IDBI had refused to finance the second-hand equipment. We shall examine each of these objections. It is true that there is no mention either in the application to SIA or in the approval by SIA or the RBI that the NRI investment would be by way of supply of equipment. However, the application to SIA as well as its approval specifically mention about the import of equipment worth 420 lakhs to be funded out of foreign remittance made by the NRI shareholder. In such cases, it is normally for the company and the investor to decide whether the investment is to be by way of remittance of cash or by way of supply of equipment, especially when there is no bar expressly stated in the approval given by SIA RBI for investment by supply of equipment. In this case, as is evident from the facts of the case, that it was decided to invest by way of supply of equipment, as is apparent from the annual report for 94-95, wherein not only in the director's report but also in the balance sheet it is recorded that the petitioner had supplied imported equipment. In this connection, reference may also be made to a fact dated 31st January 1995 from the third respondent to the petitioner, wherein the petitioner was informed that 2 consignments of imported equipment had already been sent to the hospital and that on the basis of valuation made by the customs, further disbursement of about rupees 80 lakhs was expected from IDBI. In the same facts, the petitioner was also asked as to whether he would make further investment by way of cash or by way of supply of equipment. Thus, both the company and the respondent were aware that the petitioner had supplied imported equipment, and as a matter of fact, the company had treated the cost of the same as share application money. We feel that the objection that the import of equipment was not envisaged in the SIA RBI approval cannot be raised nearly 3 years after the import and acceptance of equipment, having treated the cost of the same as share application money. In regard to the complaint of the respondent that he and the company were not aware that the equipment was second-hand, we are not able to accept this contention. According to his version, the respondent was the resident promoter of the company, and the petitioner, being a resident in USA, was only a visitor to Calcutta. Being a director, we presume that he was visiting the hospital regularly to see the functioning of the hospital. And if it is so, then he should have known about the receipt of the equipments. Even otherwise, when the balance sheet was signed by him, wherein the cost of equipment has been included and depreciation charged, being an MBA graduate and managing some companies, he would have definitely examined the documents connected with the import. According to him, he came to know that these equipments were second-hand only in April 1996, after being informed by IDBI about the letter of the petitioner dated 7th February 1996 to IDBI that all the equipments except one were demonstration equipment and as such would be considered as second-hand equipment for funding purposes. According to the petitioner, the declaration before the customs indicated that these equipments were second-hand, while according to the respondent, no such declaration was made. Even though in the reply at page 23, the respondent has stated that relevant bills of entry would be produced, nothing was produced during the hearing. Ki holo? These are of the most relevant documents in the possession of the company, which would have settled the issue as to whether the company respondents were aware of the equipment were second-hand or not, when the same were received by the company. The non-production of these documents lead us to presume that the respondent might have been aware that these equipments were second-hand equipments, even before the receipt of the IDBI letter dated such and such date as annexure R18. Then kindly come to paragraph 30. Having held that the respondents might have been aware that the equipment was second-hand, the other issue is with it. They were outdated and were unusable. Both the sides produced various documents to advance their respective stand as elaborated as a part of their argument. For us to come to a conclusion on this, we think it is enough to refer to the minutes of the board meeting dated 13th April 96, in which the board allegedly resolved not to make any application to RBI for allotment of the petitioner against the second-hand equipment. The first paragraph of the second page of the minutes reads as follows. Resolved that Mr. Shadul Gautu, Managing Director B, and is hereby authorized to discuss with IDBI the financial pattern of the second-hand equipment, their maintenance, replacement if necessary, or viability of the project, and to execute the related documents for IDBI financing and with all government department secretaries, etc. As and when, the underlined portion, as and when necessary to comply with the legal procedural formalities for import of second-hand medical equipments. A reading of the above would show that there is not even a whisper that the equipments were outdated or they were unusable or junk. As a matter of fact, a careful reading of the above would reveal that what the board had decided was to discuss with IDBI the financial pattern of the second-hand equipment and to take all steps to regularize the import of the second-hand machinery and not to condemn the same. There is nothing on record to show that any action was taken by the respondent as mandated by the board to discuss with IDBI and to comply with the procedural formalities for import of this second-hand equipment. Thus, it is apparently clear to us that on the day when this board meeting allegedly took place, the equipments were in working condition and those who attended the meeting had no grievance about the functioning of the equipment. As it is stated in the resolution, replacement would be considered if necessary. Thus, there can be no dispute regarding the good working condition of the equipment, at least up to April 1996. If I am omitting the next part, kindly come to page 236. Where's the bottom pilot about 7-8 lines from the bottom of page 236. The sentence starting with one aspect.
Yes.
9 lines from the
Yes.
one aspect which expressed during the hearing requires mention. We expressed our doubt as to whether the petitioner, being not only chief promoter but also a medical doctor by profession, would have supplied extended equipment, as he would be fully aware that these equipments were being used for treating human beings, and some of them being life-saving equipments. Any defect in these equipments would endanger the lives of the patients. If at all he had decided to play a fraud on the company, as alleged by the respondent, he could have over-invoiced the equipments, but very unlikely by supplying substandard equipment. Anyway, we do not propose to give any conclusive finding on the quality of equipments, etc., legality, validity. Then, my lord, kindly come to page 240, paragraph 33. Prior to the meeting on 16 February 1996, even though the petitioner admits that he attended the meeting, his grievance is that the minutes do not reflect the correct proceedings in that meeting. In this meeting, the IDBI nominee is reported to have advised that the draft minutes of 7th February 1996 placed before this meeting should reflect correctly the appointment of the managing director. If such an important item was not included in the draft minute, then it becomes highly doubtful whether this item was discussed at all and decision taken therein in the meeting held on 7th February 1996. Then, well, let kindly come to the next paragraph. The next crucial meeting is the one held on 13th April 1996. This meeting was held after receipt of the letter dated 4th April 1996 from IDBI that it would not fund the second-hand equipment. After considering the letter, the board decided not to apply to RBI for allotment of shares to the petitioner against the cost of imported equipment. It has not been explained as to why such a resolution was certainly passed, since we do not find any record produced before us to show that the company was earlier intending to apply to RBI for allotment of shares, and as such, this resolution was necessary. Further, in view of the later paragraph in the minutes, it indicated that the company would further discuss the funding of second-hand equipment with IDBI and would also try to regularize the import of second-hand equipment. The resolution not to apply to RBI definitely seems to be a premature decision. And then, my lord, kindly come to page 242. Paragraph 37. 37. Some of our findings are the notices alleged to have been issued to the petitioner directors for the board meeting cannot be considered to be valid notices, and as such, the stand of the respondent that the petitioner directors have vacated the office of directors under section 283(1)(g cannot be sustained. That the various decisions in the board meeting, including that of allotment of shares, in the absence of valid notice to the petitioner director, could not be considered as valid and binding, and that there is substantial evidence to show that at least up to March 1996, most of the imported equipments were in working condition, and that the conduct of the respondent directors had been unfair and biased against the petitioner and exhibits lack of probity. Thus, on an overall assessment of the allegations and our findings, it is amply clear that the petitioner has established his case of oppression, justifying grant of appropriate relief under Section 402 of the Act. The learned counsel argued that the only way by which the disputes could be sorted out is, as held in the cases cited by him, that the petitioner should be directed to sell their shares to the respondent being the majority shareholders. My lord, pausing here for a moment, my lord, lordships are aware that at a point, my lord, general law was the oppressed should sell to the oppressor. That is possibly why this, my lord, stand was taken. No doubt we have also in many cases adopted this method of resolving disputes. But in the present case, admittedly, the respondent was in minority and he became the majority shareholders only after the first allotment of shares, which we have already held was not legally sustainable, and the second allotment also has been held to be so. In view of this, the respondent cannot claim majority status. The conduct of the respondent in allotting shares to himself at the back of the petitioner and in declaring that the petitioner directors had vacated office, etc., and thus taking over the company is highly unfair and lacks in probity. If we were to accept the suggestions, contentions of the counsel for the respondent that the petitioner should be directed to sell his shares, it would only be putting premium on the conduct of the respondent. In case the High Court decision goes against the petitioner, he would cease to be the majority shareholder. Therefore, our relief would be confined only to matters relating to those which do not have any bearing on the second-hand equipment. From the facts of the case, it is clear that neither the allotment of further shares nor the declaration that the petitioner directors had vacated the office has anything to do with the second-hand equipment. In regard to the allotment of further shares, the prayer of the petitioner is that the allotment should be cancelled or the respondent should be directed to sell all the shares held by his group to the petitioner. Cancellation of the allotment would adversely affect the financial position of the company, which is not financially sound, and the direction to sell the shares would be again the approval of CI, by which the resident Indians would have share, etc. My lord, this was, my lord, this CLB, my lord. And my lord, page 246 is the final relief. Paragraph 40. Since we have held that the stand of the company that the petitioner directors had vacated office under section 283(1) cannot be sustained for various reasons, we declared that this petitioner directors will continue as directors of the company to avoid any future controversy relating to issue of notice for board meeting. We also stated that notices for all board meetings will be issued to all directors by registered post with 21 days notice to the address of the NRI directors at their usual address. Then, my lord, the shares allotted in the board meeting.
Yes, this you had placed. You had said this is the order confirmed by the Supreme Court.
And my lord, these are the findings. Well, kindly look into the conduct of this person. My lord, possibly, my lord, scathing remarks. My lord, can I have one more this time? I know, my lord, but I have to.
Yes, we understand what you're saying.
Judgment দুটো দিয়ে দিয়েছে judgment দুটো copy করে Mr. will be taking one another day, my lord. I have taken instructions for that. Would it be convenient for my lord to keep the matter from Mr. Mukherjee's reply either on 22nd, my lord, or after 30th of this month, my lord?
Either before 22nd or after.
Either on 22nd, my lord, or after 30th, man. That's for Mr. Mukherjee's reply, my lord. Mr. Mitra will take
Mr. Mitra, when will you come? Date.
Can it be next Thursday, my lord?
Exactly, that is what we were proposing, 14th. Before you commence, yes, for further submissions on behalf of Ms. Ndi.
But only one indulgence, possibly, my lord, we will not be called upon to respond on 14, my lord, because my lord, Mr. Mukherjee, my lord, maybe. I obviously support it.
So, what do you want?
No, my lord, that
Let us see what happens. 14th, you will be there.
I very well, my lord.
14 most probably, how much time you think you will take?
Yeah, no.
So after that, you don't want Mr. Mukherjee will not respond on that day.
No, my lord, either on 22nd, my lord, or any day after 3rd.
Somebody who is here should tell us on that day.
My lord, I'll appear virtually, my lord, if required.